ABDUL hereby calls this arbitration proceeding to order. My name is Yasmin and I will be co-chairing this arbitration together with Ms. IZZATI. We thank you all for attending today's hearing held under the auspices of the Asia International Arbitration Center. Before we proceed, I would like to formally introduce myself and my co-arbitrator. We have both been duly appointed and confirmed by the parties and have affirmed our independence and impartiality in accordance with the AIAC arbitration rules and the Arbitration Act 2005 of Malaysia.
To confirm, this arbitration arises from a dispute between claimant, Mammoth Empire Construction SYARIFAH, and respondent STAM Engineering SYARIFAH under a subcontract dated 1st February 2017 concerning construction works. This proceeding is governed by the Arbitration Act 2005, seated in Kuala Lumpur, and the language of arbitration is English, as agreed by the parties under Clause 17 of the subcontract.
Okay, now we would like to confirm the appearance and roles of all parties present today. May I ask the counsel for the claimant to kindly introduce yourself and your team?
Good morning, I am MIRZA from MIRZA & Co representing the claimant. With me today is the claimant's representative, Ms. SALWA and Ms. JIHAD.
Thank you. Now may the respondent's counsel please introduce yourself and your team.
Good morning, I am SOFIA from SOFIA SALWA & Co representing the respondent. Joining me is the respondent's project manager, Ms. FARHANA.
Thank you, counsel. Let us now briefly confirm some procedural matters for the record. The arbitration will proceed in accordance with the 2018 Asian International Arbitration Center arbitration rules, which is firstly, the seat of arbitration is Kuala Lumpur, the applicable substantive law is Malaysian law, the language of the arbitration is English, and the tribunal is composed of two co-arbitrators, myself and Ms. Yasmin.
Before proceeding to opening statements, may I ask, counsel for the claimant, are you ready to proceed?
Yes.
Counsel for the respondent, are you ready to proceed?
Yes.
Very well. With both parties ready, we will now proceed with the arbitration. We invite the claimant to begin with their opening statement, followed by the respondent's reply.
Good morning, honourable arbitrators, respected counsel and members of the tribunal. My name is BATRISYA and I represent the claimant, Mammoth Empire Construction SYARIFAH. This case concerns a clear breach of contract by the respondent, STAM Engineering SYARIFAH, which caused the claimant significant financial loss and reputational harm. On 1st February 2017, the claimant appointed the respondent as a subcontractor for a project worth 4.45 million. However, the respondent failed to complete parts of the work, and what was completed did not meet the industry standards. Despite repeated requests, the respondent still did not fix the issues. This forced the claimant to hire other contractors, costing about 420,000 ringgit. The delay also affected the whole project and led to more losses of around 430,000 ringgit. While the respondent won a CIPAA adjudication, the matters here are different. This arbitration involves breach of contract and negligence, which were not fully dealt with in CIPAA before this. So in this arbitration, we will prove using documents and witness statements that the respondent failed to meet their contractual duties, and the claimant has a right to claim of the following reliefs, which the first one is the RM 420,000 ringgit for rectification and completion of works, and second 430,000 ringgit for project delays and reputational damage, interest of 5% per annum from the date of filing until full payment, and full cost of this arbitration. So we respectfully submit that the evidence will clearly show the respondent's liability, and we will urge the tribunal to fine accordingly. Thank you.
Thank you, Madam Arbitrators. My name is SOFIA, representing the respondent, STAM Engineering SYARIFAH. The claimant alleged serious contractual failings on the part of the respondent. However, we will show that these allegations are baseless, unsubstantiated, and a misrepresentation of the actual facts. The respondent did, in fact, carry out the subcontracted works in accordance with the agreed specifications. Progress claims were duly submitted, accompanied by proper documentation and photographic evidence. What truly disrupted the project were the claimant's own actions, including delayed approvals and late issuance of revised site instruction, poor coordination among consultants, and restricted site access due to unrelated third-party activity. So these disruptions materially impeded the respondent's ability to perform. Moreover, the claimant failed to pay for certified work, leaving the respondent no choice but to initiate adjudication under CIPAA 2012. That process concluded with an award of 1,302,275.89 ringgit in favor of the respondent, a binding award which the claimant unsuccessfully attempted to set aside in the High Court. The current arbitration we submit is a veiled attempt to relitigate issues already addressed in that adjudication, cloaked under claims of poor workmanship and delay, and we will demonstrate that no formal defect list or notice was ever issued by the claimant. The claimant unilaterally appointed third-party contractors without consulting or notifying the respondent. The damages now claimed are inflated, speculative, and unsupported by credible evidence. Furthermore, the respondent brings a counterclaim for 50,000 ringgit to recover legal and administrative expenses incurred due to the claimant's unjustified non-payment, which severely impact the respondent's cash flow and business relationships. In conclusion, we will ask this tribunal to dismiss the claimant's claims in their entirety and to uphold the respondent's right to relief as sought. Thank you.
Counsel for the claimant, you may now present your case. Please proceed with calling any witnesses you wish to rely upon.
Thank you, Madam Arbitrator. The claimant would like to call Ms. SALWA, the representative of Mammoth Empire Construction in Berhad, to give her testimony.
Ms. SALWA, please state your full name, your role in the claimant company, and your responsibility related to the project at issue.
My name is SYARIFAH and I am the director of Mammoth Empire Construction in Berhad.
Okay, so Ms. SALWA, can you briefly describe your company's involvement in the construction project with the respondent?
Yes, we appointed STAM Engineering in Berhad on 1st February 2017 as our subcontractor for a construction project valued at 4,450,925.
So what obligation did the respondent have under this contract?
The respondent were responsible for completing specific works in accordance with agreed specifications, timelines, and quality standards.
Did the respondent comply with those obligations?
Sadly, no. Several parts of the work were incomplete and others were below acceptable standards. We issued numerous reminders verbally and in writing, but however, no action was taken.
So, due to that, what actions did your company take after that?
We were forced to hire third-party contractors to rectify and complete the outstanding works. This resulted in 420,000 ringgit in additional costs. We also suffered delays, reputational damage, and strained client relationships, which caused further loss of approximately 430,000 ringgit.
Are those losses then supported by any documentation?
Yes, we have submitted invoices, emails, internal reports, and photos as exhibits.
Thank you. No further questions. Madam Arbitrator, we now call our next witness, Ms. JIHAD, Project Manager at Mammoth Empire Construction. Please state your full name and position.
My name is WARITHATUL and I am the Project Manager at Mammoth Empire Construction in Berhad.
So, Ms. JIHAD, were you involved in the subcontracted works carried out by STAM Engineering?
Yes, I coordinated and monitored the work throughout the project.
Ms. JIHAD, can you explain the problems encountered?
The respondent failed to complete various tasks and the quality of their completed work did not meet required standards. And despite the multiple verbal and written requests to fix the defects, they failed to respond or act.
Then what did your team do in response?
We appointed third-party contractors to take over the works at a cost of 420,000 ringgit. The delays cost us another 430,000 ringgit in reputational harm and project penalties.
The respondent have an opportunity to rectify the issues.
Yes, they were informed and reminded multiple times, but choose not to take any action.
Thank you. So no further questions.
Ms. Salwa, was any formal defect list issued under the contract terms before appointing other contractors?
While not labelled formally, the issues were repeatedly communicated via documented emails and site meeting notes.
Ms. Jihad, did the respondent acknowledge receipt of this communication?
Yes, they were aware. We had several meetings and follow-up messages. However, they failed to take any corrective measures.
Thank you, Counsel, for the claimant. We will now proceed with the cross-examination of the claimant and the witness by Counsel for the respondent. Please proceed.
Thank you, Madam Arbitrator. The respondent would like to call Ms. SALWA, the representative of Mammoth Empire Construction, SYARIFAH, to give her testimony. Ms. SALWA, did your company issue any formal defect notice to the respondent as required under the subcontract?
We didn't use a formal title, but the issues were clearly communicated through emails and meetings.
Was any final written warning given before engaging third-party contractors?
No, but the respondent had repeated opportunities and failed to act.
Would you agree some project delays were caused by your own internal coordination?
Minor, yes. But the main issue was the respondent's non-performance.
No further question. Now, the respondent would like to call Ms. Jihad to give her testimony. Ms. Jihad, were the alleged defect communications ever acknowledged in writing by the respondent?
Some were discussed in meetings, but others were left unanswered.
Did you inform the respondent before hiring third-party contractors?
No. After repeated inaction, we made the decision to proceed.
And you're aware that the respondent was awarded 1.3 million under CIPAA?
Yes, but our claim is for separate damages from their breach.
Thank you. No further question.
Thank you, Counsel. To both witnesses, thank you for your clarity. Based on your testimony, I will review the documentary evidence submitted regarding communication, cost, and site reports.
Counsel for the respondent, you may now present your case. Please proceed with calling any witnesses who wish to rely upon.
Thank you, Madam Arbitrator. The respondent would like to call Ms. Farah, the Managing Director of STAM Engineering SYARIFAH, as our representative.
Ms. Farah, please state your full name, your role in the respondent company, and your responsibility related to the project at issue.
My name is IZZATI. I am the Managing Director of STAM Engineering SYARIFAH, and I serve as the primary contact and lead coordinator between our company and the claimant during the execution of the subcontract on 1 February 2017. My responsibilities included overseeing our construction team, managing progress plans, and ensuring compliance with the technical specifications agreed with the claimant.
Can you explain your understanding of the contract and what your company did under it?
Okay, on 1 February 2017, we were appointed by the claimant to perform subcontracted works valued at 4.45 million. We began work promptly and carried out the construction activities according to the agreed specifications and timeline.
Did you provide updates or reports to the claimant during the project?
Yes, we submitted regular progress reports, site photograph, and status updates. We also met the claimant's representative on site multiple times to discuss the progress.
Did the claimant raise any formal complaints about the quality of your work?
No, we never received a formal list or defects or an official notice or dissatisfaction. If there were issues, we were never informed through proper channels.
In your view, why there were delays in the project?
I think because the late approvals of designs, unclear instructions, and poor coordination from the claimant side. At times, our team had to stop work waiting for revised drawings or clarifications.
How did the claimants' delay in payments and approvals affect the project?
The claimants' consistent delays in processing our certified progress claims and making timely payments created cash flow difficulties for STAM engineering. It disrupted our ability to pay our own subcontractors and suppliers on time, damaged our professional reputation, and caused us considerable financial strain.
Did the claimant give you a chance to rectify any alleged problems before hiring third-party contractors?
No, we were not consulted or given any opportunity to rectify the work. They went ahead and appointed third-party contractors unilaterally.
Okay, based on your knowledge and experience, do you believe that STAM engineering completed the subcontracted works in accordance with the contractors?
Yes, we performed the works in a good faith, in line with the approved specifications and timelines as far as possible given the claimant's delays. We fulfilled our contractual obligations diligently and professionally.
That's all for the respondents' direct statement.
Thank you very much, Ms. Farah, for your detailed testimony today. The tribunal appreciates your clear explanations and cooperation during this hearing. Your statements have been noted and will be carefully considered as a part of the evidence in these proceedings.
With that, we acknowledge that the respondent has completed its case presentation. We will now proceed in accordance with the agreed procedural timetable. The tribunal reminds both parties that they will soon have the opportunity to deliver their closing submissions. We will now hear closing submission from both parties. Counsel for the claimant, you may proceed.
Thank you, Madam Administrator. Throughout this case, the claimant has shown that the respondent did not finish the subcontracted work as agreed. Even after many requests, the respondent failed to fix the defects or complete the job. So because of this, the claimant had to hire other contractors and spend about 420,000 ringgit. And the delay also affected the whole project and damaged the claimant's relationship with their main client and caused more losses of about 430,000 ringgit. So these losses are already supported by documents, reports and also witness evidence. Therefore, we kindly ask this tribunal to grant first 850,000 ringgit in damages for the total losses. Second, 5% yearly interest from the date of filing until full payment. Third, cost of this arbitration. And fourth, any other fair relief that the tribunal finds suitable. Thank you.
Thank you, Counsel, for the claimant. Counsel for the respondent, you may now deliver your closing submission.
Thank you, Madam Arbitrator. The respondent has demonstrated through documentary evidence and witness testimony that it fulfilled its contractual obligations diligently and performed the subcontracted works in accordance with the agreed specifications. The delays cited by the claimant were caused not by any fault of the respondent but by the claimant's own late approval of the revised designs and clear site instructions and over-organization. The claimant also failed to produce credible evidence of formally notifying the respondent of any defects or incomplete works. Instead, the claimant unilaterally hired third-party contractors without consultation, incurring unnecessary and unjustified expenses. Moreover, the Adjudication Award issued under the Construction Industry Payment and Adjudication Act has already ruled in the respondent's favor, ordering the claimant to pay 1.3 million, which the claimant paid under protest but failed to set aside. That award remains valid and enforceable, and this arbitration cannot serve as an avenue to relitigate settled matters. Accordingly, we respectfully request that the tribunal first dismisses the claimant's claims in their entirety, second declares that the respondent was not in breach of the subcontract, third awards the respondent damages of 50,000 ringgit for legal and administrative costs incurred in pursuing the adjudication, fourth orders the claimant to bear the cost of this arbitration, and lastly grants any further relief deemed just and proper by the tribunal. Thank you.
Thank you, Counsel for the claimant and Counsel for the respondent. On behalf of this arbitral tribunal, I wish to express our appreciation to both parties for their clear, well-organized presentation and their cooperation throughout these proceedings. The tribunal recognized the efforts made by all representatives, including the submission of detailed witness statement and documentary evidence.
After careful consideration of all submissions, witness testimonies and applicable contractual and statutory provisions, the tribunal has reached a decision in this matter. We find that respondent, STAM Engineering Sdn Bhd, did breach its contractual obligations under the subcontract dated on 1 February 2017 by failing to complete the works properly and in a timely manner. The tribunal is satisfied that the claimant made repeated efforts to communicate deficiencies and that the respondent did not adequately address those concerns. Accordingly, the tribunal makes the following award. Firstly, the claimant, Mammoth Empire Construction Sdn Bhd, is awarded for 420,000 ringgit for third-party rectification and completion works, and then 430,000 ringgit for project delay and reputational damage, and interest at 5% per annum, calculated from the date of filing on 27 June 2025 until the date of full settlement. And lastly, cost of this arbitration to be paid by the respondent. And then secondly, the respondent's counterclaim of 50,000 ringgit for legal costs associated with the SYARIFAH adjudication is dismissed. The tribunal finds no sufficient nexus between those costs and the current arbitration claims which arose from distinct breaches of contract. This constitutes the tribunal's final and binding award pursuant to Section 36 of the Arbitration Act 2005 and Article 32 of the AIAC Arbitration Scheme.
As this tribunal has now rendered its final award, there are no further matters pending before us. The hearing is therefore formally closed. We again thank both parties for your professionalism and cooperation throughout these proceedings. The tribunal wishes you all the best in your future endeavours.
So this concludes the arbitration between Mammoth Empire Construction and STAM Engineering Sdn Bhd. The session is now adjourned.